we have to have, thank you, recording. Got it, signed that contract. So, at some point, the lifetime of those people, whether it be founding board members and or people of any organization are going to move on, and they need something to go back to reference, even if they're going to make changes. And so you need that well articulated, kind of like the Constitution, that it becomes a living document in some ways and comes back as a frame of reference.
Great. That's really helpful. So to clearly delineate the responsibilities of each party so that you're not being reactive, in a given situation, what each party is expected to do. And so that you have a living document beyond staff turnover at either the authorizer or the school. Those are some great reasons. Any other final comments?
It's kind of to reiterate what other folks have said, but it defines the relationship between the two parties. Who's responsible for what, the areas that each operate in. And I always like to say that it's a two-way street, because as an authorizer, we have responsibilities that we owe our schools, as well as the schools having responsibilities they owe us. And so delineating what that relationship looks like, I think that's how I like to look at a contract.
Great. That's really helpful. So now we're going to start by taking a look at what's in statute. Within the Colorado Charter Law, it states that there must be a contractual agreement, of course, called the charter between the school and the authorizing district, and that the charter has to be based on the approved charter application. And it should be a document that reflects all of the agreements between the authorizer and the school, including what district policies do not apply to the school. And the contract must also include a list of all of the automatic waivers to state statute that the school is invoking, as well as any non-automatic waivers that the school is requesting to be released from. And the Colorado Department of Education has a list of all of the automatic waivers that charter schools are released from on their website. And then in cases where schools would like to request additional waivers, they have to request that from the State Board of Education. Finally, the initial contract has to specify the manner in which the district will support any startup or long-term facility needs of the school, including any actions that the school is responsible for taking in order to make sure that its capital construction needs are met. So CACSA has developed a standard contract that we're going to take a look at in a few minutes. It's an update from the 2018 standard contract on CDE's website that includes all of the statutory requirements within the template. There are also statutory requirements related to the timeline. So first of all, Colorado Charter Law requires all initial charter contracts to be for a period of at least 4 years for district authorizers. But as a best practice, CACSA recommends that initial contracts are for a period of 5 years and that renewal contracts are for not longer than 5 years. And when establishing the contract, the authorizer proposes the initial contract, and then both parties have a 90-day timeline to negotiate the contract, and then the authorizer has to provide the finalized contract to the school. Contract provisions can be subject to appeal if they're unilateral conditions. So that means if an authorizer is imposing conditions on the school that they haven't negotiated with the school, those can be interpreted as being unilateral conditions, and the school may appeal those. We're going to dive deeper into the negotiation process in the next session of boot camp. However, here it's important to know that Colorado statute outlines the timeline for negotiating the contract, and that there's also provision within statute that speaks to the dispute resolution process as well. So similar to other statutory requirements, information regarding waivers is also included in the CACSA standard contract. All charter contracts have to include a list of all of the automatic waivers given to charter schools that they're going to invoke. And as I mentioned before, there's a list of those automatic waivers on the CDE website. And then the contract also has to include a list of all non-automatic waivers that the school is requesting. There's a separate process outside of the contract that the authorizer and school need to go through in order to request a non-automatic waiver, which includes providing the rationale. They have to explain why they're requesting this additional waiver, and a plan for each non-automatic waiver that the school is requesting. And then once the contract is finalized, the local board delivers requests for non-automatic waivers to the state board by submitting a signed copy of the contract, which is then either granted or denied by the state board within 45 days. So this is an area that has continued to evolve in the state procedure, and the state board is often now asking districts to oversee and confirm that the replacement plans for these non-automatic waivers are actually being implemented and put in place. So I'm going to pause here for any questions about the statutory process so far.
Is there a mechanism from the authorizer's office about judging the waiver, the quality of the waiver, as far as it meets the requirements or doesn't prior to submission?
Tom, would you like to respond to that?
Yeah, is Paola on this call? I don't know if Paola's here or not. If she's not, Kelly's saying no. So the great answer to that is that Paola Paga, who's part of the Schools of Choice unit at CDE, will review your non-automatic waivers and the replacement rationales ahead of time for you, which we have used frequently here in Jeffco to have the Schools of Choice unit take a look at those non-automatic waivers and replacement rationales to kind of sign off on them, to suggest sort of standard language that has passed muster in the past with the state board. And so if you have an applicant that's new or renewing and you're now at the contract stage, of course, when you submit your final signed contract along with the requested state waivers to the state board, you can always send those non-automatic waivers and replacement rationales to Paula at the CDE Schools of Choice unit, and she will look at them and make suggested changes so that those go through more easily than might be otherwise. So that's a resource that I have used a lot that's been super helpful. And maybe Kelly could speak to that more because I know she's been involved with that as well. But I strongly recommend that you do that ahead of time before you send in your final contract with final waivers.
That's super helpful. Thanks, Tom. Kelly, did you have anything to add to that?
No, I was just going to put in the chat, her Paula's contact information is on the bottom of that automatic waiver webpage on CDE's site that I just linked above, but I'll put that in the chat as well. But I think that's a great tip, Tom. Thanks.
Great. Any other questions? Okay, so now we're going to move on to talking about the CACSA standard contract. So the CACSA standard contract is available on CACSA's website, and it's a detailed document that covers about 17 different sections of the contract. You can see them here, ranging from academic accountability to food services and many other topics in between. The contract includes all statutory requirements for charter contracts in Colorado, and it also draws from language used in contracts by other high-quality authorizers in the state. It covers all of the required topics and includes other sections that you may want to include that are considered best practice. And it's intended to be used as a template for you to build on. You're going to want to modify it for your own purposes and, of course, have your legal counsel review and approve it. So the sections in the contracts cover basics such as the initial contract term, which, as we mentioned before, has to be at least 4 years, to student enrollment. It includes transportation, and everything in between, or well, many things. So the contract is intended to be used as a resource for all authorizers in the state. It's been developed by CACSA to ensure that the needs of all students are really being met through the charter. It's a customizable template, as I mentioned before, so that you can make sure that you're including all of the details in the contract that you need to include to hold your schools accountable in your portfolio. And then once the contract is established, this is the founding document that both you and the school will continue to reference back to throughout the course of the school's life cycle. Charters are legally required to uphold all requirements that are written in the contract. And the model contract we're going to talk about a little bit today can bring both you and the school closer to ensuring that the school is meeting all legal requirements and that the schools are safe and that students are able to access a high quality education. So as I mentioned before, the CACSA standard contract is a customizable template. It has a number of sections that districts are going to want to change that are highlighted in yellow that should be customizable to the district context. And then in some sections of the contract, there are sometimes different options for language to use depending on the needs of the authorizer and the school. For instance, if you need language regarding an online program. In general, it's important that authorizers use this model contract as a foundation and make sure that they're making adjustments so that it aligns with the approved application of the school that they're working with. And it's clear in statute that the finalized contract an authorizer holds with the school should be based on the approved application. The contract template also has a bunch of really useful footnote or endnote citations in green that provide guidance or considerations for the authorizer to think about in fleshing out or developing a particular section of the contract. So before we move on, Alex, do you want to add anything else about the CACSA model contract, how it was developed, how it's intended to be used?
Yeah, I would just a couple things. Can you hear me? Sorry.
Yes.
Number one, like most of our products, we're really looking for feedback on it. And so we're really curious to see people use it and to make it into a living document and to give us suggestions for how to continue to update it. Number two, I would say that, we're trying to get at solving frustrations that people in the field had over how to intervene when a school was problematic, but not bad enough to revoke or non-renew. And so there's more language there. The other piece that we are hoping to do over time is to link it to a version of a special education MOU, which is something CSI does. And we were hoping to put these two out at the same time with this contract that's sort of links up with and meshes with a special education MOU, which we thought would be a better practice to help on that front. But we couldn't really reach closure on how the MOU would work. So that's something we'll be working on this year. And I will say the other part is you have to make this work as you're managing up within your district with your general counsel and the law firm that you work with. So a lot of districts work with Kaplan and Ernst, for example, and they have their own template. And so we've coordinated with them, hoping to influence and get their feedback to make it useful to them. So it could be that when you use the model contract, you might be picking and choosing sections from it rather than the whole thing, depending on your local legal context. And that's intended to work as well. So whether you use the whole thing, whether you match it with an MOU on special ed, or whether you pick and choose elements from it, it's meant as a resource for you. And we can help with that if you have questions about which language to use. So with that, and we are excited to get feedback from people who bring it into their work.
Great. Thanks so much, Alex. Does anyone have questions about the CACSA model contract or how it can be used?
I would just add that there is a special population lens to this new model contract that you should be aware of. And also something that I think can be really helpful is if you've already have charters in contracts. And as they're coming up for renewal, I think it's really interesting, an interesting study that can help you think forward. One is reviewing and comparing that old contract to the new one, and thinking through sort of, are they legally aligned as things have changed since the last renewal? Because sometimes things will become outdated, I would say, and understanding of what those are. And sometimes also thinking through a particular school, what challenges you may have had over the period of the contract, if any, and if so, what would that look like? And are there changes that need to be done in the contract, or would you keep the contract intact with a model contract with some conditions, not unilateral conditions, but conditions either way? So those are just some different approaches to think about as you're considering what you currently have. Having worked with old contracts and been so thankful when a charter was going up for renewal, because I really could update it rather than going through a whole, it's a huge process to go through to try to update a contract prior to outside of a renewal.
Great, thank you. That's really helpful.
Oh, one other thing I would say too is that when you get into the negotiating process, having, especially if you have multiple charters, having the standard or the beginning point of the contract negotiation is good. And so as a district, it's in your interest to figure out sort of what your starting contract is as you work with the schools. And if you start, like in any negotiation, figure out where you are starting from, and then you're going to move away from that. But if you haven't figured out what your district's hoping to achieve and have that sort of as the beginning point, then you may not be in as strong a position to actually deal with things you want to deal with. So if you have multiple charters, it's not a bad idea to sort of figure out what your district's version of the beginning point is, and the CACSA standard is supposed to help with that. One other resource, I'll put it in the chat. We did a good side-by-side analysis of several of the contracts, like CSIs, DPSs, the one Kaplan and Ernst uses the most. And so you can break out individual sections and look at that resource as well, and find multiple examples of how districts and charters have negotiated the details of some particular piece, like transportation or accountability.
Great, thank you, Alex. So now we're going to hear a little bit from Tom McMillan from Jefferson County about the contracting process and how it works in their district. So Tom, can you provide an overview of the contracting process in your district?
Yes, we send the contract to the charter and they sign it and send it back. So does anybody have any questions about that? No. In Jeffco, we have a standard contract that has been provided for us through the services of Kaplan and Ernst, as has already been mentioned. They represent lots of different districts, but we work real closely with Kaplan and Ernst. Every year when we're coming up on a renewal or a new contract situation, we start out by asking Kaplan and Ernst to take a look at our standard contract in light of the CACSA new standard contract, to see if there are any modifications or updates that need to be made. So we work with our outside counsel pretty exclusively on coming up with a draft, and we call it that. We call it a draft. So once we have the sign off from our board that we have a new charter in process or a renewing charter in process, we start out by sending a draft to the charter applicant, asking them to run it past their attorney for their review. I would say 90% of the time, because it's sort of a standard, generally accepted contract, Our charter folks don't really have a whole lot of changes that they ask for. There may be some tweaks around special education that needs to be updated. There may be some tweaks around the purchase services contract, which is sort of a rider or an outside contract that goes along with the main standard renewal or initial contract. But generally, I would say about 90% of the time, outside counsel for the charters may just have some small minor housekeeping kinds of changes, because it's really pretty standardized at this point, at least for the most part. The other 10% of the time, you may have a charter make or suggest some pretty significant changes to the contract. And we will take those, into consideration. There's sort of a standard in the legal world about contracts of adherence, which is take it or leave it. We really do not look at our contracts that way. We like to have the same sort of essentially standard contracts across the board, because that way, if there are changes that need to be made across all the contracts in the district, we're not doing those on a onesie-twosie basis, but we're able to say, this is a change in the law that needs to be reflected in everybody's contract. So change paragraph 7.2 to say this. So we kind of try to steer people toward a standard form, but that's not to say that if there's a particular charter that's particularly unique, has a unique program, some of which we do have in JEFCO, around funding for students with special needs, those kinds of things. We're not averse to talking with our charter folks about particular changes, but we do try to honestly steer folks to sort of a standard format. So one of the things that we very often need to do is change the timelines, change the deadlines for contracting. So for example, very often, as you know, when we have a renewing charter application that's supposed to be submitted by December 1 and approved by the district board by February 1, most of the time that doesn't work, because of timing of meetings and things like that. So very often we will have an agreement with the charter attorney and with the charter board to waive those deadlines a little bit, or modify those deadlines a little bit, to give everybody sufficient time to review the contract drafts that are floating around and come to a meeting of the minds. In my time doing this, I have yet to run into a situation where we had a charter telling us that what we were saying was a unilateral imposition that needed to go to the state board. I find that most of the time the attorneys that we work with are pretty collegial. They get along pretty well. And most of the time we don't really have big arguments about what's included in a contract. Again, because throughout Colorado over the years, people have pretty well come to a meeting in the minds about what a charter contract ought to look like and ought to say. So apart from submitting the waivers ahead of time to CDE for review, which I think is always a great idea, I strongly encourage people to do that, and sending out drafts ahead of time so that there's a discussion draft floating around and red lines, so everybody is understanding what is the suggested changes. It goes really, in my experience, it goes really pretty smoothly. So that's kind of how that works, apart from the opportunity to mutually agree on sliding deadlines a little bit. That often happens just because of the vagaries of different people's calendars. And then the modifications, the second question.
Yep.
You want me to go ahead and talk about that, Robin and Kelly?
Sure, I do have a couple of questions.
Oh, sure. Go ahead.
So if there are significant changes to the contract, who needs to review them before they go to the board for approval?
So in Jefferson County, it comes to me first to review them, to talk about whether these are really kind of outside the pale of what we're doing with everybody else, or if this is just a modification based on the unique program that a particular charter might have. And so that's kind of a a fork in the road to decide, you know, yes, these modifications are appropriate given the uniqueness of your program, or this is kind of outside the guardrails of what we're doing with everybody else. We need to talk about this a little bit more. So I, as the charter liaison, would be the first take at that. And then, of course, I would run that by our outside counsel, which in this case is Kaplan and Ernest, for them to weigh in on. So.
Got it. Thanks. Yeah. So then on to the second question. What modifications are included in your charter contracts for particular schools?
Yeah, so some of the modifications, again, would either reflect the particular nature of the school. For example, as you all know, probably we have a charter school in Colorado that's unique in Colorado and unique really in a lot of ways nationwide, because it serves 100% students who have profound hearing loss. And so every kid in the building is on an IEP, and that results in some changes to the way students with special needs in that particular charter are funded and taken care of by the district. So that's one in particular that has to do with the unique nature of that school. Another one, we have a charter school, as a lot of you do, that is an AAC that serves overage, undercredit English language learners, new immigrant students. And so because they're an AAC, there are differences in the way that we track their accountability in terms of growth and academic performance. And so those are a couple of kind of the easiest ones to think of. Most of the time, again, most of our charters, whether it's a Montessori school or a Waldorf inspired school or a core knowledge school, most of them really fit within the standard guardrails, I'll say, of the standard contract. But we are flexible enough to accommodate those schools that have a unique focus or a unique student population. And I think, as maybe Alex can speak more to this, you know, there's some proposed rules at the state board level around students with special needs, which probably will drive some changes to standard contracts across the board for all districts in the state. I don't know if Alex wants to talk about that or not, but you know, we always have to pay attention to what's going on at the legislature. We always have to pay attention to what's going on at the state board to make sure that what we're contracting for with our charters is within the standards that the legislature and the state board is now putting out. So I don't know if anybody wants to speak to that or not, but every year it's a little bit different. I'll put a footnote to that. In the past, Jefferson County, and I don't know if other districts do this or not, but in the past, Jefferson County just routinely had a yearly contract amendment that just got set out, and charters would sign off on it. Most of the time, those yearly contract amendments were pretty much housekeeping. We haven't had to do those in the last couple of years because we haven't had a lot of changes that needed to be reflected across the board. But that is another tool in the toolkit that authorizers may use in some circumstances to say, hey, there's a big change that affects everybody. We need to have an amendment to everybody's contract that would go out maybe on a yearly or every other year basis, just to reflect updates that are happening outside of our control. So
basically to reflect legislative changes or new regulations or rules.
Changes in funding, those kinds of things. Yeah.
Yeah, I would. That's a good point, Tom. I would just add that, like all the contracts include language about thou shalt, comply with federal and state law and regulation and guidance and all sorts of things. So as those things change, the contracts have places where you can point to and say, hey, you said you'd follow the law has changed, you still have to follow it. But it's really hard sometimes when it gets into any of the gray zone for the contract to sort of tie in people's hands when they're trying to make a change to update it. I will add also, for those of you that are new to Colorado or our charter sector, should know that historically about 8 or 9% of the Colorado charter schools have exceedingly long contracts. So we early in the sector had 20 to 30-year contracts, which is not a good practice. We strongly recommend against it. And we believe that when you renew a contract, it should not be longer than 5 years on the renewal. But you should know some districts stick to that. Some districts do renew with longer terms. and that all the more makes it necessary to have the mechanisms in place to correct things on an ongoing basis. Yeah, some of the districts and some of the schools really want like their 20 and 30-year contracts and want to keep them when they get renewed.
Wow. That's long. So now we're going to go ahead and move on and talk very briefly about pre-opening requirements. And so outside of the contract, many authorizers use pre-opening requirements. There are a separate set of actions that a school has to take in order to be deemed ready to open. Many of these are based on the application where reviewers may have seen holes or gaps or areas that needed to be strengthened before the school's ready to open. But others are just standard pre-opening requirements that you would expect any school to meet in order to be ready to serve students effectively on day one. CACSA has a list of suggested pre-opening requirements that many authorizers use as a foundation for developing their own. And, it includes things like having an enrollment policy, having a roster of enrolled students, having all kinds of, student and family policies in place, having governing board bylaws, of course, having hired staff. And then it's also helpful to indicate due dates for each of these types of actions so that the school knows when all of these should be expected to be completed in order to be ready to open on time. These pre-opening requirements could be an actual checklist that you give to the school, and then the school submits it back to the authorizer. And that way, the checklist can be used by the school to assess themselves and determine whether they're ready to open. And frequently, schools will need to submit evidence with this checklist to indicate that they've, accomplished each of the actions that are required. And then the checklist can also be used by authorizers during a site visit, pre-opening site visit, or an initial site visit. So I think someone is going to chat a link to a number of resources to support authorizing schools in year 0 that was developed by CACSA. So that should be useful as well.
And some of our most experienced districts like DPS have really good stuff to steal, as does CSI in this case. Both CSI and DPS have good stuff to borrow.
Yeah, Max is, I don't understand how we do anything without Max sometimes. He is a very meticulous and on top of like all dates and small items, and we get into meetings every other week and go over all those task items. I will say this is the, in Philadelphia, we did not have this type of contract and or like even skeletal contract in this way. And we definitely didn't have like an opening checklist. It was more of a here it is, take it or leave it kind of situation. And then there were like negotiations around enrollment and stuff like that. But this is so much better and very well laid out. I really thank you for the resource.
Great. That's helpful.
I would just add, you should know in the world of tricky politics between a school board and a school, and for the people that are new to this, sometimes the districts will approve a charter application that is not really ready. And they're compromised, and the staff will say, hey, these people really are not ready. You shouldn't approve them. Here's the reason why. And the board will say, well, they might be able to achieve those things. And so frequently we have boards, and I'm not naming any ones that are here, but hypothetically, a local school board will approve a charter application that's really not ready. And that increases the importance of these year 0 benchmarks dramatically. And sometimes they'll do it with the knowledge that they don't expect the school to reach the benchmark, and they're trying to avoid an appeal to the state board based on a denial. And so they approve them, and then the contract becomes the thing that can be appealed to the state board because of the year 0 benchmarks. You should just know that political rat's nest problem can arise in Colorado in lots of districts, and what is one of the leading up challenges for the authorizing staff to try to manage that responsibly and to try to counsel people towards like saying no if they really mean no, and then making sure all parties understand that the benchmarks really are meant as potential things that the school may not ever achieve. And that's not an unlikely expectation. In fact, the school board thinks it will happen.
Great, thank you. So now I'm going to turn it over to my colleague Steve, who's going to talk about contract negotiations.
Yeah, thank you, Robin, and thanks. Wonderful opening conversation around your charter contract, and couldn't agree more with, I believe it was Stacy, I apologize if I've attributed it incorrectly, who identified the sort of wonderful resources that you have available, both in the year zero checklist, but also the model contract itself, light years ahead of where I can tell you where we started in my state of Nevada. But we're going to talk a bit about contract negotiations, and I'll just briefly touch on the sort of statutory foundation upon which you allows you to negotiate or requires you to negotiate a contract, really in good faith with the charter school. And then we'll open it up again and have a discussion about the sort of reality of what these negotiations look like. And I think my notes I've got sort of echoing in my head the opening conversation around the idea of using the negotiations and the contract as a way to manage up. And importantly, through the negotiations, ensuring that, I think Alex had mentioned this earlier, making the hard stuff a little easier in the contract itself, and not losing that as you negotiate or negotiate away from what you need to keep in your contracts. This is we're here, you know where we are and where we're headed. I think Robin did a fine job covering that. And we hope at the end of this session, you'll leave with an understanding of the statutory requirements related to the negotiations and steps that you can take to negotiate the contract. And then secondly, that you'll have an understanding of the requirements related to modifications. So contract modifications and steps that you'll need to take to negotiate or modify a contract. So both the initial contract and then any modifications that you take. We kind of have three buckets, if you will, of the types of contract negotiations that you'll likely be engaged in. Obviously, the initial contract negotiations for a new charter school that you approve. The second type of negotiation would be triggered by a modification or a proposed amendment to an existing or executed contract. And then, of course, upon renewal and entering into negotiations that are triggered based upon a charter school's renewal. The term length conversation, obviously, here as well. So there are multiple sections within Colorado charter law that speak to requirements when it comes to negotiating charter contracts. The negotiation process is first mentioned in section 106, which states that the charter applicant and the local board may negotiate a contract, including a number of provisions like the use of a building or the provision of shared services or activities or other undertaking by the school that might be carried out or agreed to between the local board and the charter school. Statute also states that the school may negotiate with the district regarding the use of a school or the provision of services. And I think that was mentioned by Tom as a rider to sort of the contract, these service exchanges between the charter and the districts. Additionally, a school may appeal to the state board if they disagree with particular conditions that are established within the contract. And I think that's, and we'll probably speak to this as we discuss the negotiation process and some potential changes or conditions that you might seek to install in the charter contract when we get to the authorizer discussion with Alex. But it's key that obviously that appeal process remain front and center. And then finally, funding is also a topic that would be negotiated or may be negotiated between the school and the district. CACSA obviously recommends using the most recent model contract, not only because it meets the statutory requirement and reflects best practice, but also helps guide you through the negotiation process. I'll just, again, underscore the strength of that model contract. I found particularly useful the footnotes that you all have installed, Alex and team, whoever else was engaged on this call in that development process. Really helpful footnotes for an authorizer to think about and to think through. The model contract is written in a way for districts to modify the contract. You had heard about it through the sort of yellow highlighted sections, as well as other sections in the contract that are kind of called out where you would want to customize specific language. You were introduced to this during the contract phase, but we'll mention it here again. Notwithstanding any agreement otherwise, you have 90 days from the vote of approval for the contract to be executed between the local board and the charter school. We mentioned sort of conditions and interesting language in your statute related to conditions, and the idea of unilateral conditions, which I hope we can discuss a little bit, and especially Alex, your experience. I think Alex had mentioned in renewal or upon initial charter, a board may want to utilize year zero as a way of approving a school, avoiding an appeal, and sort of kicking the decision down the road, and using a year zero or pre-opening checklist as a way to do that. There also could be conditions that you'll need in the contract beyond the initial checklist, and this is part of I would imagine, the relationship experience and the human experience between you and the charter school and the boards to negotiate conditions that are not unilaterally imposed. Unilateral conditions can be tricky, and boards and staff should obviously consult with legal counsel about the appropriate way to codify or pursue such conditions. Handling these issues correctly during the initial or the renewal process and in the board resolution are important parts to implementing conditions that are less likely to be appealed to the state board and then potentially overturned upon appeal by the state board. During the negotiation process, it's important to revisit and to consider your authorizing office and your mission and vision. We had discussed this early on, and ground sort of key decisions in your mission and your vision. It's clearly stated in law that any changes or additions to the charter contract need to continue to uphold the charter school's autonomy and not limit their flexibilities given to charter schools in the state of Colorado. In addition, there may be times where you may want to seek input from community members to ensure that all decisions related to the negotiation and potential changes are in the best interest of students and families. And then, as we heard earlier, consulting with your legal counsel throughout this and periodically is incredibly important. In the chat, there'll be a question. When might an authorizer feel like they would want to seek community input in a contract negotiation? Has anybody sought community input as you thought about or as you conducted the contract negotiation? Alex, I see you've come off mute.
I was gonna say, I think you're more likely to have community input go on during the application review process. And so, and maybe if you use a DAC during the renewal process, you might have that community input, and then you'd have, let's say, the community concerned that the school's admissions and location doesn't look like it's going to serve very many low-income children from the placement of the building, right? And so from that input, you're like, yep, that's a priority for the district, and the community raised it, and we want to make sure we get it into the contract somehow.
Right.
So I don't know during the negotiation where that would be likely to come up, but I do think you can definitely have a to-do list that's generated by the community input earlier, but it's sort of moderated by the state board. Otherwise, you're going to get, it is important to keep in mind, you know, what the school can appeal to the state board and what the state board will look at during that appeal.
Helpful. Yep. Like a checklist from the open meetings to carry over into the negotiation process.
Yeah, and all that's where it goes back to the importance of like training your DAC or chairing and facilitating the community meetings appropriately, so that you end up with something you can act on, rather than something that, like, the school looks back at the record of that meeting and it sounds like it was just charter hate going on. Then it doesn't give you much to stand on if you're trying to actually affect the later contract.
Very good, thank you. So let's we'll kind of delve into some examples where I think a lot of the learning is in how the negotiation process. So let's talk to some experienced authorizers, and what I'd like to do is maybe first start with Alex, and then maybe hand the mic around to Amelia. I know that you've gone through this process, so if you feel like you want to come off mute and speak to it following Alex, and any others. But let's discuss about how you have done this work with negotiating sort of the contracts. And so, Alex, from your perspective and from your work in CACSA and across the state, what have you seen in terms of the process of negotiating contracts, and what have you kind of witnessed in terms of tough negotiating processes between districts and schools, and then we'll pass the mic around for specific district examples.
I think I see in chat Amelia's got to go in about 5 minutes, so I think I'd have them jump in this first, and then I'll follow in after. Amelia, you want to go first? Or Tom, who also is going to leave.
There's Amelia just came off of mute.
Sorry. Finding the mute button. I think with contracting with schools, I really feel like the contract phase has been, if you get to the contract phase, really, then you're good. I think that there's always it's the pieces that lead up, and I think was it Alex who was just sort of alluding to some of those pieces. It really is a significant process that gets you to the contract place where you're going through your DAC, working with, we have 3 different entities that are reviewing the application. And so it can be in keeping people out of the weeds, and so that they're at that high level and understanding the legal components around what our obligation is with a renewal, and keeping them out of picking up on little things, right? So that you can focus on the meaningful components and ensure that, that there's that accountability and oversight in building that next phase. I think that that's the biggest piece that I've seen in where it can get complicated. With regards to the actual contracting, I feel like that's pretty easy. I do think some of the other where I've seen more significant challenges is really around what are potential conditions that you're putting on a school. And, I have had schools claim that we were putting universal conditions on them, and had appealed to the state board. So we sort of had to move through that process, and it was determined that we had not. In fact, we were collaborating with the school the entire time, and the board, the school board the entire time. So the state board said they didn't have jurisdiction, as an example, right? And had it come back to our district to continue to negotiate some of those pieces and get the things in that we were hoping to see, that we thought might provide some guidance, oversight, but the idea really is to get the school back on track if they are off track. I don't know if that answers your question.
Indeed.
Steve.
Yeah, no, Amelia, could you give us a little bit more detail? And sorry that you have to jump off here shortly. Could you give a little more detail about the complaint that was raised to the state board by the school, and what you were able to evidence against that complaint, that it sounded like it was successful in terms of coming back to you and the school?
For this particular school, we had a number of Office of Civil Rights complaints. We had we had some 1 o'clock in the morning community board meetings, where the community really showed up and were struggling, and they had challenges that were both supporting the school and in opposition, but significant concerns. So community concerns, a lot of OCR complaints, some leadership turnover were some pieces. So we had and then a lot of Title IX complaints in addition to that. So we had a variety of different pieces that gave us some evidence that we needed and wanted to intervene in the ways that we did. And I think where the state board sent it back to us is that we really did a pretty good job of meeting with the board ahead of time, talking through some of our concerns. We had that documented in email. We had that documented in a variety of different forms, including just conversations that we were meeting with them, but formal meetings and written concerns. And it was through that we even we submitted our essentially we submitted our what we wanted to put in to demonstrate conditions. We gave them those conditions. They gave us some feedback. We made some adjustments to those conditions, and that was further evidence that we weren't doing a universal conditions, because they had, I think, just ruled against Poudre Valley School District on that same piece. So essentially it came back to us in the school, and we just continued our process. I think that the school felt that they had made improvements even with all of the challenges and concerns, and felt that they needed and deserved a 5-year contract. And we were saying, potentially a 5-year contract with a variety of conditions. Does that help?
So much. Yeah, that's a fantastic example. Fantastic example. And it sounds like one of those schools that Alex was referencing, in between. Not so bad you can rule against and non-renew, but that there needs to be some improvement, and that you've documented it successfully, your collaboration, so that you could sort of beat back the claims of a unilateral condition being placed upon the school. That's a great example. Thank you, Amelia. Alex, I see you're off mute.
Well, I don't know if we still have Tom before he disappears as well, but Tom, any Jeffco or earlier Dougco stories, if you're still on?
Oh boy, we got stories, but going to new, not talking about renewals for a second, but going to new charter applicants and new contracts, and kind of circling back to pre-opening conditions. Kind of an important safety tip that was news to us that we needed to start doing was our outside counsel. When it comes to pre-opening conditions, a lot of times we would just have a little rider, or it would be pre-opening conditions would be incorporated into the board resolution approving of the application, saying, okay, the application is conditionally approved subject to the following, bang, 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 have your enrollment at X by X date, and have a facility by Y date, and on and on and on and on. Those would all formerly be contained only in the approval resolution that our board would adopt. Outside counsel was saying, if you do that, those may not be really enforceable because they're not technically in the contract. So what advice we received from outside counsel was, yeah, go ahead and put them in the approval resolution, but also put them explicitly in the contract so that if things are going sideways and the applicant is not able to open on time, or they don't have the enrollment that they expected, or they don't have a facility, or whatever it is, that all stays within the four corners of the contract and whatever the dispute resolution language in the contract is, as opposed to, oh, these are unilateral conditions, I'm going to appeal to the state board. Alex may have some input on this, but I know there was a situation very similar to that where it went to the state board and state board said, we got nothing to do with this. This is a contract problem. You guys go away and figure it out among yourselves. And so that's kind of where we want to be. We don't want to be in front of the state board on an appeal. We want to be negotiating on the terms of the contract in the four corners of the contract, rather than, you know, standing up in front of the state board and having all that brain damage. So Alex may want to weigh in.
I will just add one thing, and Tom's the only one here who is a lawyer, I think. I'm definitely not a lawyer, and all this is prefaced by make sure you're talking to your legal counsel in your district and, you know, having the good legal advice. We had a big session on this a couple of years ago, and Kaplan and Ernst, a couple of the lawyers weighed in. One of the key things is that one of the things that makes it not a unilateral condition that they can challenge is that it's being negotiated. So when the school board has a resolution to approve a charter or to approve renewal, and they have concerns, what they're saying is, we approve the school with these conditions that we direct the staff to negotiate with them. And then that is negotiated, and the district can be as hard-nosed in the negotiation as they need to be. But it's not just a unilateral thing that's in the school board resolution, but that there's no opportunity to have any exchange with the school about it. And so the trick, that's where the lawyers need to be involved in the wording of your resolution language, so that you can codify all the conditions and then still keep yourself in the safe ground for the contract negotiation, but also not create an illusion that you're flexible on them. Like, you're negotiating how you get to those conditions and what it means. And it has to be something, you can still have a unilateral condition. It's just, it's really tricky the way it's approved by the board and incorporated into the contract. And that's where you want to have the lawyers involved in designing how you talk about it with your board. Tom, does that make sense from your experience?
Yeah, I think that captures it well, Alex. And I apologize, folks, I have to jump off, but thank you so much for your time. I appreciate it today.
Yeah, thank you. Thank you for sharing, Tom. I appreciate it. So the next question for the whole group to tussle with, we won't go into small groups. We'll just do the whole group for purposes of time and size. Does your district have a policy or process for conducting contract negotiations? And secondly, if anybody wants to come off mute to address the first question, they can also, if you wish, address the second. Who reviews the contract or amendments in your district? Or maybe importantly, who needs to find out if you've got a process, or you need to maybe investigate a bit to see if you have a process or a pattern perhaps that has become your process that you've now inherited. Well, important to consider all that we've discussed, and important to think about the process that you will have to adjudicate your contracts and initiate the negotiations. I think important points that we've heard thus far are, it's a part of a long process, including the public meetings and the approval process that can then roll over into the contract negotiation. Important discussion that your board would have and language it uses as it directs you to negotiate a contract, perhaps with conditions or pre-opening terms with your schools. And I see, Alex, you're off mute, so by all means jump in.
Yeah, I would just say that this is one of those processes that you kind of want to buffer from the politics of your school board and the pressure on the board. And so it's one of those things where hopefully your superintendent is sort of, and your legal counsel are saying, hey, we're working on this. We'll bring it back to you once we have it negotiated, so that you're not having the charter people feel like political pressure on the school board on the side can get them to cave on something in the negotiation. So you do want to sort of, I think, separate this from the political discussions that should have gone on before. And then once the contract comes back, then it's a chance for the board to approve it. But you really don't want the school board members, at that table or in those calls working on the details. And I guess the other thing we haven't raised is the unique issues that come up when you're dealing with an EMO or a CMO, because you end up with sort of two contracts needing to be worked out. You'll be the contract between the board that receives the charter and the EMO or CMO, and then there'll be your contract with that board. And sometimes part of it that's been complicated lately is figuring out what's in each of those two contracts. And we can talk about that more in detail, but I do think, and the charter, the CACSA model is designed to sort of take some new lessons on that from the last decade. But that's another thing, like sometimes you're dealing with the district pressuring the school's applicant to renegotiate their proposed contract with the provider who's going to run the school. And that's a whole parallel contract negotiation that the board, the district is right to insist on language in that other contract and have it be part of what they're figuring out. Because otherwise they don't have any legal pull over the actual operator if they have two different contracts and they conflict with each other. So anyway, I just raised that. So you want the right people talking about it, and you want the right scope of the negotiation. And that scope gets bigger once you're dealing with EMOs and CMOs. Great point.
Great point. Okay, so moving us through here so we can get you out on a break on time. We had said initial contract is one of the types of negotiations that you'd enter into, and another is during a modification. Obviously, any substantial change to the original contract would justify a contract amendment. And we've given you some examples here as to what might a substantial change look like. Oftentimes, these are referred to as material changes to the charter, to the contract that then would render and elevate themselves to a modification. This is just an example of what the process might look like for you in your policy and processes. Obviously, a written request from the school's governing board, and there might be a discussion or negotiation with you as to whether or not it raises to that level in advance of this. But then you would review that request. You might want to meet with the school to talk about it, and then ultimately it gets raised to your board for to approve or not approve the modification or amendment to the contract. Then there's the third type, which would be during renewal. And I think Tom did a wonderful job talking about, and Amelia talking about renewals and the contract negotiation process. Here there are some points. I'll just raise the last point, which was that I think, what did you say, Alex? 7 to 8% of the schools in Colorado have extended terms, and that best practices during your negotiation would render a 5-year contract at renewal stages. This is most likely the point at which the conditions would come in, and all of the conversation would apply here for non-unilateral decisions to be made and then appealed to the board, especially when you're talking about schools, as Alex had mentioned early, and I think we had good examples of not performing at a level poor enough to non-renew them, but clearly needed some work to be done. This is likely where the majority of that time is spent. Okay, before we send you off to break, any questions or reactions or ideas based on this discussion about negotiations? Okay, seeing none, let's go to break, and we'll come back at how about 13 minutes or 10 minutes from now, so 23 after the hour. 23 minutes after the hour, and then we'll jump into our next conversation.
All right, we're going to come back together in just a few more seconds. I see some folks turn their cameras back on. Thanks. We know that you're back with us. And we're going to round out today's boot camp with a final session on compliance monitoring, which we've got a lot of content to cover. So we're going to dive right on in. So in this session today, we're going to talk about compliance monitoring on a variety of topics. So we'll start with talking about monitoring academic performance, then we'll dive into financial performance, operational performance, and then we'll talk specifically about some special populations, including English language learners and special education. And we're going to pause throughout it to kind of talk about some case studies in this session too. So we hope that this will be a helpful session for you to not only see what's in statute, but also hear from each other on how you might handle some case studies or scenarios. So there's that roadmap again. We're kind of shifting now. We've gone past the contract negotiation and finalization, and we're now looking at what it looks like to monitor schools throughout their life cycle. Our objectives from this session are that we hope you become familiar with the compliance topics that you are required to monitor and begin to understand how these topics are typically monitored in districts in Colorado. This deck will be a great resource, but by all means, we don't expect you to memorize everything we cover in the session today. In this session in particular, there's a lot of terms and acronyms that we're going to cover. So we're going to link that same resource that we linked during week 1 of boot camp that just has a full list of all the terms and acronyms. We'll try our best to kind of break those down. We saw in some survey feedback that some of those terms might be new for folks, but feel free to reference that full document that Robin just put in the chat right now as well. So I'm going to pass it over to my colleague Lauren to dive in. Go ahead, Lauren.
Thanks so much, Kelly. So to kick us off, we're going to start with a discussion on why monitor. So there are additional reasons for authorizers to have a plan to regularly monitor the performance of schools that they authorize beyond those legal requirements. These include things like strengthening the relationship between authorizers and the school leadership, including the school leader themselves and the board, familiarizing yourself with the school's program, supporting successful compliance check-ins through relationship building with the school, monitoring the school's special education and ELL programs for compliance, which we will discuss as we proceed both through this session, but also in subsequent sessions. And then monitoring schools' financial and operational performance. This is particularly relevant as we know that many charters fail not just because of academic performance, but also for operational and fiscal issues. So given this, we will cover all of the responsibilities, both academic, financial, and operational, as we go through compliance responsibilities for authorizers. Before we dive into the academic performance, I wanted to see if there were any initial questions or feedback from the group. Okay, and if not, we'll just go ahead and kick off with academic performance. So Colorado's Education Accountability Act of 2009 articulates essential monitoring components of districts' monitoring responsibilities. This law requires the Colorado Department of Education to annually review all schools and districts in the state and to assign performance ratings. And both school ratings and district accreditation ratings are based on 3 key performance indicators. These include academic performance, academic growth, and post-secondary readiness. Based on these ratings, CDE then makes recommendations to the state board on the type of improvement plans for lower performing schools and or districts that they are then required to implement. While this law does not speak directly to authorizer responsibilities, it's still important for authorizers to monitor schools' performance framework ratings or SPF, and to also monitor any schools that receive a priority improvement or turnaround rating. We will discuss each on the next slide. This law also specifically identifies assessment requirements, which authorizers should monitor for compliance as well. And so in addition to these state performance ratings and Colorado's law, the federal law, ESSA, or the Every Student Succeeds Act, requires identifying schools in need of the most support and improvement. And this law also emphasizes historically disadvantaged populations and high school graduation rates. Lastly, Colorado's law also requires schools and districts to convene an accountability committee. And this committee's responsibilities include things such as making recommendations on spending priorities and discussing school improvement strategies. Again, district authorizers should ensure these requirements are being met as well. So next, we're going to discuss Colorado's charter school law within the academic performance monitoring context. So this law specifies and requires that districts annually review schools' progress, meeting the goals and objectives articulated in their contracts, and any state identified goals in their improvement plans. Authorizers are also responsible for monitoring the implementation of schools' turnaround plans based on their school performance framework, or the SPF, as we discussed previously. If a school is not making adequate progress towards the goals and/or continues into a third year of implementing a turnaround plan, the district authorizer has the power to revoke the charter and to close that school. So next, we wanted to pose a question or scenario, excuse me, to the group to get everyone engaged. And feel free to either unmute yourself or to share your comments in the chat. So for this scenario, ABC Academy has received a priority improvement rating in 2018 and a turnaround rating in 2019. The question to the group is this school required to present to their local board a summary of the changes the school is making to improve its performance? Question one. Question two is, based on their ratings, does the authorizer have justification to revoke their charter? Any thoughts or feedback on how you would proceed with this scenario and these questions? And/or if there is a relevant experience that you want to share or a question related to the scenario, please feel free to chime in with that feedback as well.
I will share that this is all pre-pandemic and the pausing of the ratings. So this one is not quite a trick question, but that this is before we stop counting.
Yes, thank you, Alex, for that super helpful context. Okay, well, oh, sorry, go ahead, Alex. I was gonna go on.
No,
I
was just gonna see what other people's answers are for not trying to get it wrong or anything. But I will say that the turnaround leads to turnaround plans schools have to have. And that because they've got those plans and the districts are involved in basically accrediting their schools, the district has to be in a position to sort of review and approve a plan. So you do kind of need to have that process take place, but it's driven more by the state accountability system than it is by the charter system. So as a school of the district, that's sort of an obligation that's going on here. That's my answer. Am I right or wrong?
No right or wrong answer.
No right or wrong?
Said. No right or wrong.
That's my take. And I think the districts would be, they'd want to remind the school of that and push them to do it, and then push them also to make sure that the plan is well developed. And I think they should push them if they find a plan is developed that's not really dealing with stuff. So that becomes a hook they have that's not really based on the charter law necessarily, although the threat of revocation is there, but that they it's one of the schools in their district and it's on the state's clock. And that's something we're trying to get CACSA members to think about. It's like, well, how do you leverage that through charter accountability? Anybody else?
Any other thoughts or feedback before we move on to our next monitoring topic? Okay.
Yeah, let me just add the last 30 seconds on that. Because things are on hold because of the pandemic, what the state did was pause changes in the ratings, and without the testing, people kept the previous ratings. They are implementing a request to reconsider process, and they haven't finalized it. And if you're into that, you want to get into the depth of that, it's a great discussion. We've talked about it at CACSA, and we can go on. But the process involves the state review panel visiting and using alternative data to get off the clock. That's likely to change this next year, and they're likely to start sort of transitioning back to using those mechanisms. So this stuff will go, and it'll be a long period since interrupted between testing and the clock being applied. And so there's probably going to be some fights over districts trying to apply these mechanisms and charter saying, how dare you? Even though legally the districts have the right to do so. So we anticipate that this will be a big issue in the next couple of years. And no one knows the answer of how it'll work out. So there's definitely not a right answer to that one.
Definitely not. Thanks again, Alex. A lot of things up in the air over the upcoming years, for sure. So moving on next to financial performance. This is also addressed in state law through Colorado's Public School Finance Act of 1994. So this act provides funding to charters in the same manner as traditional schools. And under the law, funding levels may differ due to mill levies across districts. In addition, this act, under this act, state and local general fund revenues are distributed to districts on a per pupil basis. And the per pupil amount includes a base per pupil amount, in addition to amounts or factors that are unique to the district, such as the at-risk student count, the cost of living, and the overall district student enrollment. Schools are responsible for their own operating budgets and for contracting for services as they need. And state law also requires that district authorizers annually review schools' financial performance based on each school's financial audit. Schools that either fail to meet generally accepted standards of fiscal management and or violate any fiscal legal provision are subject to having their charter revoked under state law. And so with that, we're going to move on to scenario 2 regarding financial performance and compliance. So for this scenario, if a school in your portfolio does not complete an annual audit during the first year of operation, what do you think your next steps would be? Oh, you might be on mute. I can see that you're talking, Kenlyn, but I cannot hear you. Is that just me? Sorry, still. Maybe if you want to post your feedback in the chat, definitely want to hear your thoughts. And as Kenlyn's doing that, did anyone else want to come off mute and share how they might address the scenario? Or any questions that you have in response? Hi, Michael, see that you came off mute. Go ahead.
Hi there. This is actually kind of an interesting question for me. The new charter school that my district, they're in their first year right now. The person who's kind of running it told me that charters aren't audited in their first year. So this question kind of would seem to fly in the face of that. So I guess that's just a question that I have, is if a charter school is audited in their first year or not.
I do not believe that the law specifies that charters in their first year aren't audited, but
Okay.
Alex, I see that you're off mute, so please feel free.
Yeah, they'd also be getting the CDE grant, the startup grant, and have a bunch of money that needs to be spent appropriately in most cases, at least lately in Colorado. I think the vast majority of new schools are getting the grant. So I'd push back on that one based on the assurances they've made in order to get the federal grant. So I think you'd be in a good ground saying, no, you've got money. You need to do the audit in the first year. But I'm not aware of other districts that have taken a different perspective on it. And it's a good one to follow up with CDE on in the schools of choice unit and ask them.
I'm almost wondering first year, you mentioned the charter school grant. I'm wondering if they were counting that as their first year, or if they're counting, this year as their first year. Okay. Yeah, when he said that, I was a little taken aback, but yeah, I'll definitely follow up with CDE on this one.
Yeah, I'd be curious to see what other practices are. A while ago, NACSA did its survey and found that a really large number of authorizers weren't looking at the audits in the first place. And so back when I was at NACSA, we went and changed state laws to require an annual review of the audit by all authorizers. And Colorado is one of the states that added that to the statute. And so I'm not familiar with any exceptions for, once they're chartered, that doesn't apply. So I'd be surprised. And I think you'd be on good ground to insist.
Okay, thank you.
It depends if they don't have any money yet. Like if you've approved them and they're incorporated, but they haven't received any money yet, and they're in one of those year zeros where they're doing other stuff, and they don't have the federal grant, then they might be able to say, hey, we don't need to be audited yet. We don't have any money yet as a nonprofit. And that would be appropriate. But if they've got a bunch of money coming and going, then I think it's fair game.
Yeah, well, this year they're getting their PPR. So, this year would be, from my perspective, a normal year.
Yeah, absolutely. Once they're a public school getting that money, I think you're right to demand it. I think it's more about year zero or a planning year where there might be fair to check with CDE on and see where you stand.
Well, yeah, they're year zero. They didn't have anything budgeted for any type of audit or anything. So, and really for them, it was really just a couple months last year that they were even started up on their grant. So, okay. All right, thank you.
Great question, Wested.
And thank you, Michael, for that follow-up. And Kenlyn, sorry that we couldn't hear you, but thank you for your feedback in the chat as well. This is a good segue into our next slide on financial performance and compliance around grants. As a follow-up, I don't believe that the charter school program law specifies not auditing in year zero, but agree with Alex that that's something to follow up with CDE on. So in addition to that, monitoring schools' performance, or excuse me, financial performance also includes monitoring their compliance with grants as well. Federal grant funding will likely flow to schools through the authorizer, particularly for CSP recipient schools. And the same remains true for the recent COVID stimulus funding, such as the CARES Act. It is important that authorizers monitor schools' grant management compliance and these requirements, even if the district has financial and/or accounting staff who monitor these things as well. So student enrollment is also a critical operational component that authorizers should monitor as well. This includes during the planning year to ensure that schools are on track to meet their established enrollment targets as specified in their applications, in addition to tracking schools' enrollment by student subgroups such as gender, race, or ethnicity, English language learners, and students with special education needs, students who are low income and or qualify for free and reduced price lunch, and gifted students. Since schools funding is largely derived from FTE students, authorizers should track schools' future enrollment goals and projections as well. So with that, we're gonna, again, turn to you and pose our third scenario around monitoring enrollment, student enrollment. So what tools or resources might you use to monitor the enrollment of students with disabilities and English language learners? That's question one. And is there a right enrollment percentage you should hold students accountable to, excuse me? Does anyone have feedback on this, either how they've handled it in the past or questions that they have about how they might handle this moving forward?
Right now, we use Google Sheets. So I just put together an October count list every year, and have just tracked it every year, where I have total enrollment for each school, special education students on IEPs and other enrollments, put in the percentages and the staff that are allocated at each of those, so we can track that and the growth over the years. And, you know, we've looked at the enrollment, and we're always shooting for at or above the state average when it comes to the special education numbers, because that's more clearly defined. Sometimes when we look at other groups, I don't know if we look at proportionality to the district from the charters, but we have such a large geographic region, and there are various neighborhoods and just patterns of growth and development do make that interesting, since the charters are choice schools.
Great, thank you so much for your feedback. And Michael, I see that you're off mute. Did you have a question or?
I was going to say something kind of similar to what the previous speaker said, just about, you know, looking in the October count information and, you know, tracking that. As far as what do you compare it to, I mean, my district is smaller, you know, both population and geographically. So we really haven't discussed it yet, but like in the contract, it talks about, you know, kind of being, you know, in line with what the overall district is for, you know, special education, ELL, those types of demographics.
Great. Thanks so much.
Oh, sorry.
No. I was just going to say, Marianne, I see that you came off mute, please. Go ahead.
I think I would add to, like, yes, looking at comparable percentages to district and state, but also when you're looking at the regions or the areas in which the charters are, I think comparing them to comparable schools within the district. So, you know, in the district I'm at, depending on where you're at, they have higher percentages of student populations. And so, not to say, you know, that you're making an excuse for a charter, but if, you know, the neighborhood district school nearby has a similar percentage of students with disabilities, I think my concern more than lies in what's the trend. Is the charter maintaining that current percentage of students with disabilities if it is lower than the district average? Do they have, you know, things that aren't seen as clearly by data, like twice exceptional students and things like that? You have to pull out and look at that story. So I think, like, service level data is important, but then what is the story underneath it, and the trends are also important to highlight.
Absolutely. Thanks so much, Marianne. Alex,
I was just going
additional thoughts?
Yeah, I don't think anybody from CSI is on the call right now, but CSI's equity screener is on another really cool tool used by one of our, you know, big authorizers. And they don't really use it. They do not use it for big A accountability purposes, but it gives them a pretty rich amount of data on enrollment and outcomes and discipline for all sorts of populations. I recommend it as something, you know, CSI is willing to do it for other districts. So it's a cool resource available to you from CSI, which I think people should leverage more. So.
Great. Thanks so much, Alex. So moving on, and as we've covered a bit already, operational performance is another critical area for authorizers to monitor. Schools that fail to meet these goals are also subject to being closed. And so operational and performance includes, as we've discussed, student enrollment, as Alex noted, student discipline, but also school governance and other systems and procedures within the school as well. For example, human resources. So student discipline and monitoring student discipline includes confirming that the student code of conduct for the school is detailed in that school's contract, tracking the school's adherence to their own school discipline policy, and ensuring that their policy also complies with IDEA for students with special education needs. Monitoring schools governance includes tracking the school's board membership and turnover, monitoring to see that the board is having consistent and timely meetings, also ensuring that the school is adhering to any governance laws that we will cover subsequently, and then also reviewing important board actions. Lastly, authorizers should also monitor school staffing models, particularly staff turnover and schools' compliance with notifying parents if their school is accused of any criminal activity and any complaint that might arise from such allegations. It is likely that each operations compliance component should both be monitored annually and as indicated in CACSA's annual report template, which we will review in a different session, but that operational compliance should be reviewed during the renewal process as well. So moving on, and my colleague Robin is going to post in the chat now on this topic. Under state law, local boards that approve charter schools must also annually provide any information requested by CDE to evaluate charter school effectiveness statewide. Authorizers should monitor schools' facilities as well to ensure compliance with state code, and also safety regulations and additional security requirements. Schools should also have floor plans and emergency routes in place, and authorizers should check on this as well. Another area for authorizers to keep track of is schools' bell schedules and transportation plans. Those should be incorporated into your monitoring checklist as well, just to review as you're looking at your school's performance. So other additional compliance topics, authorizers should also monitor complaints received by schools that they authorize, especially those from parents and guardians. In the event that these complaints arise, authorizers should direct the parent or guardian back to the school to ensure they've exhausted the remedies articulated in the school's complaint policy before bringing it to the district level. And if the parent has already done so, the authorizer should refer that parent or guardian to their district level grievance policy. Complaints related to special education and or students' health and safety require exceptions. In addition, external organizations may file complaints as well, and those schools may bear the responsibility related to those complaints. Authorizers may have to respond as well. So these issues might include COVID safety, other health and safety issues, transportation, and or board member complaints directly to the district. So moving on, we're gonna, I know that we are coming up short on time. In the next slides, we're gonna speak to English language learner compliance and special education compliance, but those will also be covered in future sessions. So to the extent that we're unable to address all of this content today, it will be covered in the coming weeks. So English language learners are students who speak a home language other than English and whose level of English proficiency is not sufficient for them to learn in classrooms where English is the language of instruction. These students are also referred to as limited English proficient students. ELL and LEP students are served in English for Speakers of Other Language, or ESOL programs, and there are numerous applicable federal and state laws to this student subgroup. So under federal law, ELL and LEP students, or students whose parents are not proficient in English, cannot be denied enrollment in any public school, including charter schools. The same holds true for students with special education needs. Given this, charters must have enrollment policies that articulate a process for enrolling students when they have more applicants than seats without preferences. And the policy must also not discriminate against ELL students, including those who are born in the US and those who are immigrants as well. Statute also requires that schools' procedures include a process to identify LEP students through assessment and provide instruction in ESOL and in basic subject areas. The program must also specify a process for exiting students from the program. It must also speak to the qualifications for teachers and must also address parental involvement in their students' education. Again, looking at the time, the Colorado law also speaks to requirements for ELL students under the English Language Proficiency Act. And we will cover that in the next, or the upcoming session, I should say, on ELL students. But for now, I'm going to skip that content and move on to additional ELL compliance monitoring. So as we've discussed, schools are required to identify and assess ELL students to determine their eligibility for appropriate services. And there are additional monitoring topics, such as instruction, parental involvement, exiting the ESOL program, and staff qualifications. We'll cover all of those topics again in the next session, but wanting to get you out on time, we're going to go ahead and move forward to special education compliance. So as I mentioned, like ELL students, there are state and federal laws that require equal access for students with disabilities. And Colorado's law also prohibits rejecting students with disabilities from enrolling within a charter school. Under federal law, or IDEA, there are various requirements for students with disabilities. These include child find, having an individualized education program for the student or an IEP, providing the free and appropriate public education or FAPE, ensuring that students are educated in the least restrictive environment, or LRE. And then there are additional requirements for authorizers as they are looking at how the schools are providing special education programs for the students at their schools. So I know that was a huge amount of information to share, and we did not provide today all of the details, but we will cover with respect to students who are English language learners and have special education needs in future sessions. And so with that, I'm going to turn it back over to my colleague, Kelly, to wrap us up.
Great, thanks, Lauren. And then like we said at the top, we know this is a lot of information thrown at you, so please use this deck in the Google folder as a resource. But related to this topic, then the next thing we just wanted to cover quickly is around when this monitoring takes place. So all of the topics that we discussed today, they're definitely part of the renewal process evaluation, which we're going to have a session on next week. But we also know that you should be looking at these things outside of just when it comes up for renewal time. So state law indicates that a school's initial charter contract must be for a period of at least 4 years. And like we said, best practice is to make sure initial contracts are for no longer than 5 years. And regardless of the contract length, authorizers should be monitoring schools at least annually and especially if there's any high stakes reviews in that renewal process. But these are not topics that you should look at only when it comes time for that contract renewal. And so next week, we'll also talk about the annual report that was developed by CACSA. So that's a great tool that you can use for evaluating a school's performance. However, like we said, that does not mean that authorizers should only monitor compliance during renewal or even annually. Best practice is also to look at these things potentially even monthly, and especially during site visits. And this kind of came up from Tina and Jane already, but some tools that are used to monitor schools. And they asked about a pre-opening. We talked about the pre-opening checklist, but they asked about a compliance checklist. And there are some districts who have great checklists that are already established, like Aurora, which Alex mentioned. But there's other tools that you have in your tool belt to do this monitoring. So like I said, that could be through the annual report, could also be through site visits, and renewal. And we're going to go through in depth those 3 topics later in boot camp and walk you through some of the resources that have been developed on how to collect some of this information with compliance monitoring. And like I said, you can also develop additional checklists to monitor these things outside of the annual report, site visit, or renewal time. I'm keeping my eye on time, and I know that was a whirlwind for all of the areas of compliance that you are responsible for. And like I said, we're going to cover a lot of those specific topics next in 2 weeks in our next week for boot camp. But want to make sure we respect your time and get you all back to the many other things on your plate on time. So we've got about a minute. I'd love to open the floor if there are any questions or concerns, or Alex, if you want to jump in and say anything else specific to this topic.
Just specific to this topic, I think we'll talk about it in a couple of weeks. But the other thing is there are some software packages, including charter tools, that help districts do this and automate it, which is actually a good thing to do because it reduces the burden on the schools and the district. And we can talk to a couple of the districts who have experience with it. But I would encourage, if you're not using one of those and you're burdened by this and the schools feel burdened, then there's some technology actually to make this work easier. And we'll talk about that later.
Great. Thanks, Alex. Well, that wraps up week 3 of boot camp. Just as a quick reminder, we do not have a session next week because of Thanksgiving, but we hope to see you back for week 4 on Wednesday again, December 1st at 12 p.m., where we can dive into site visits, annual reports, and the renewal process. There's a link in the chat to our survey. If you wouldn't mind just answering those 3 questions real quick before you move on to your next task, we would really appreciate your feedback. And just thank you so much for joining us today and for your participation. And we will see you on December 1st.
And one last thing before we go, the monthly authorizer only call is tomorrow at noon. So for the authorizers, feel free to join us for that. Friday at noon, our renewal during COVID group is meeting. And the next quarterly authorizer meeting with CDE is on Friday, December 3rd. So mark those things on your calendar and join us when you can. Thanks a lot, Wested. Great job.
Thanks all.